Hi, so this video will be the last canon for the bar syllabus of CPRA, and this is Canon 6, Accountability. So let's begin. By taking the lawyer's oath, a lawyer becomes a guardian of the law and an administration of justice. As such, the lawyer shall observe the highest degree of morality, adhere to the rigid standards of mental fitness, and faithfully comply with the rules of the legal profession. Failure to honor this covenant makes the lawyer unfit to continue in the practice of law and accountable to society, the courts, the legal profession, and the client. So how it is instituted? So for proceedings for disbarment, suspension, or discipline of lawyers, it can be commenced by number 1, by the Supreme Court on its own initiative. Number 2, upon the filing of a verified complaint by the by the Board of Governors of the Integrated Bar of the Philippines or IBP, or by any person before the Supreme Court or the IBP. However, a verified complaint against a government lawyer which seeks to discipline such lawyer as a member of the bar shall only be filed in the Supreme Court because IBP has no jurisdiction for government lawyers. Number 3, a verified complaint filed with the Supreme Court may be referred to the IBP for investigation, report, and recommendation, except when filed directly by the IBP, in which case the verified complaint shall be referred to the office of the bar confidant or such fact-finding body as may be designated. So suspension, it is the temporary withholding of the lawyer's privilege to practice his profession for a certain period or for an indefinite period of time. Ang disbarment naman, it is the act of the Philippine Supreme Court in withdrawing from an attorney the privilege to practice law. So restorative justice is not retributive. It's the goal in disciplinary proceedings against lawyers. So the main objects of disbarment and suspension proceedings are the following: to compel the attorney to deal fairly and honestly with his clients, to remove from the profession a person whose misconduct has proved him unfit to be entrusted with the duties and responsibilities belonging to the office of an attorney. Next is to punish the lawyer, although not so much as to safeguard the administration of justice. Next is to set an example or a warning for the other members of the bar. Next is to safeguard the administration of justice from incompetence and dishonesty of lawyers. And lastly is to protect the public. So what are the proceedings against a government lawyer? So if there is a complaint against a government lawyer, like when a complaint is filed against a government lawyer, the investigating commissioner shall determine within 5 days from assignment by raffle whether the concerned agency, the ombudsman, or the Supreme Court has jurisdiction. If the allegations in the complaint touch upon the lawyer's continuing obligations upon the CPRA, or if the allegations, assuming them to be true, make the lawyer unfit to practice the profession, then the investigating commissioner shall proceed with the case. Otherwise, the investigating commissioner shall recommend that the complaint be dismissed. Next is the proceedings against members of the Judiciary. So complaints for disbarment, suspension, and discipline filed against incumbent justices of the Court of Appeals, Sandigan Bayan, Court of Tax Appeals, and judges of lower courts, or against lawyers in the judicial service, whether they are charged singly or jointly with other respondents, and whether such complaint deals with acts unrelated to the discharge of their official functions, shall be forwarded by the IBP to the Supreme Court for appropriate disposition under Rule 140 as amended. Let's also discuss preventive suspension. After receipt of respondent's answer or lapse of the period, therefore, the Supreme Court, on its own initiative or upon the recommendation of the IBP Board of Governors, the Office of the Bar Confidant, or the fact-finding body referred to in Section 30, may suspend a lawyer from the practice of law during the pendency of the investigation for a period not exceeding 180 calendar days, or until such suspension is lifted by the Supreme Court. In order to prevent interference with or obstruction of the investigation, tampering, concealment, or destruction of evidence, intimidating or exerting undue influence on any witness. Now let's discuss quantum and burden of proof. In administrative disciplinary cases, the complainant has the burden of proof to establish with substantial evidence the allegations against the respondent. And substantial evidence is that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. So you just try to read the cases of Rico versus Salutan, case of Buntag versus Toledo. It's about the burden of proof. Okay, in this case. Okay, you also have the case of Tan versus Alvarico, also about quantum of proof of evidence. Okay. Moving forward, let's discuss the executory nature of the decision or resolution. So it's immediately executory for also be furnished copies. So the decision or resolution pronouncing the respondent's administrative liability is immediately executory. The copies of the decision or resolution shall be furnished to the office of the bar confidant, the IBP, national office, and local chapter to which the respondent belongs, and the office of the court administrator for circulation to all the courts, or OCA. Next is the sworn statement after service of suspension. So upon the expiration of the period of suspension from the practice of law, the lawyer shall file a sworn statement with the Supreme Court through the office of the bar confidant to show that the petitioner during the period of suspension, number 1, has not appeared before any court, tribunal, or other government agency, whether in respect of current, former, or prospective clients. Number 2, that he has not signed or filed any pleading or other court submission. Number 3 is that he has duly informed his or her clients, law firm, law school where the lawyer is teaching, legal clinic, or other legal service organization of which he or she is a member regarding the suspension. And he has not otherwise performed any act directly or indirectly that amounts to the practice of law. Okay, so the sworn statement now shall state the date of the lawyer's receipt of the order, decision, or resolution imposing the penalty of suspension, as well as a list of the lawyer's engagements affected by the suspension, indicating the relevant court, tribunal, or other government agency, if any. Next is the resumption of practice of law. The sworn statement shall be considered as proof of the suspended lawyer's compliance with the order of suspension. Such lawyer shall be allowed to resume the practice of law upon the filing of the sworn statement before the Supreme Court. However, any false statement in the sworn statement shall be a ground for a complaint for disbarment. And within 5 days from the filing of the sworn statement in the office of the bar confidant, that remains that there is a false statement stated therein, it shall refer the same to the courts for its immediate action. Let's talk about judicial clemency. A lawyer who has been disbarred may file a verified petition for judicial clemency after 5 years from the receipt of the order, decision, resolution of disbarment. So the verified petition for judicial clemency shall allege the following. Number 1, that the verified petition was filed after 5 years from the receipt of the order, decision, or resolution of disbarment. Number 2, that the disbarred lawyer has fully complied with the terms and conditions of all prior disciplinary orders, including orders for resolution. Number 3, that he or she recognizes the wrongfulness and seriousness of the misconduct for which he or she was disbarred by showing positive acts evidencing reformation. Number 4, that he or she has reconciled or attempted in good faith to reconcile with the wronged private offended party in the disbarment case. or if the same is not possible, an explanation as to why such attempt at reconciliation could not be made. And where there is no private offended party, the plea for clemency must contain a public apology. And lastly, number 5, notwithstanding the conduct for which the disbarred lawyer was disciplined, he or she has the requisite good moral character and competence. Moving forward, any of the following allegations may also be made in support of the petition: that he or she still has productive years that can be put to good use if given a chance, or there is a showing of promise such as intellectual aptitude, learning or legal acumen, or contribution to legal scholarship and the development of the legal system, or administrative and other relevant skills, as well as potential for public service. So the Supreme Court shall decide the petition on the basis of clear and convincing evidence. Okay, it's not substantial but clear and convincing evidence. Next is the prohibition against employment of disbarred or suspended lawyer. So a lawyer who has been disbarred or suspended shall not be employed or engage in the practice of law, including the performance of the following acts. First, providing legal consultation or advice. Number 2, appearance on behalf of a client in any hearing or proceeding before any court, tribunal, or other government agency or office. Third, appearance as representative of a client at a deposition or other discovery matter. Number 4, negotiate or transact any legal matter for or on behalf of a client with third parties. Number 5, receiving, disbursing, or otherwise handling a client's funds. Number 6, teaching law subjects in any educational institution, or acting and being commissioned as a notary public. So a suspended lawyer shall immediately cease and desist from the practice of law until the suspension is lifted by the Supreme Court. Any client previously represented by a suspended lawyer may engage the services of a new lawyer. The disbarment or suspension of a handling lawyer shall not terminate the lawyer-client engagement between the client and the law firm unless the client chooses otherwise. Okay, that's the end of the discussion for this video. For the next video, we're going to discuss the new code of conduct for the Philippine Judiciary. Thank you for watching this video.